Court of Appeal in the 5th District of the State of Florida is now in session. The Honorable John N. Harris, Judge presiding. All persons having business before this court draw near, your attention will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
All right, good morning. Welcome to oral argument session here at the 5th DCA. As Marshall indicated, I am Judge Harris. I'm joined on today's panel by Judge Boatwright to my right and Judge McIver to my left. One more case remaining on the docket today. It is case 23-3739. Each side's going to be given 20 minutes for the argument. Appellant can reserve as much of that 20 minutes as you would like for a rebuttal. I will set that as a default at 5 minutes. If you want anything other than that, please just let me know and I'll change the clock. A couple other things to keep in mind. If you have any cell phones, other noise-making devices, please silence them or turn them off at this time so that the proceedings are not interrupted. That goes for you folks out there in the gallery as well. And we are being recorded and live streamed on YouTube, so just keep that in mind, whatever that's worth. All right, this time, appellant, if you are ready, you may proceed.
May it please the court. My name is Leonard Collins. At council table with me is Richard Broom, the city attorney for the city of Titusville. I'd like to reserve 5 minutes for rebuttal.
Yes, sir.
There are really two main arguments that we're going to make today. First, the charter amendment proposed by the appellee, Speak Up Titusville, is preempted under Florida law. And second, that the ballot title and summary of that proposed charter amendment significantly understate the breadth of the charter amendment itself. By way of factual background, the proponent of a measure, the appellee Speak Up Titusville, proposed a change to the charter of the city of Titusville. And the title of their proposed amendment, what the voters saw, was Right to Clean Water Charter Amendment. And the ballot summary, what was provided to voters, was, shall the charter of the city of Titusville be amended to recognize a right to clean water and prohibit actions which interfere with this right? Y/N, yes or no? We believe that the language of the charter amendment and the language of the ballot title and summary fail to inform voters of the full measure of the matter. And so,
What did they fail to notify the voters of?
okay, so when you read the language, shall the charter be amended to recognize a right to clean water? The right to clean water, just in and of itself, doesn't tell voters what it is that they are voting upon. It is unclear, reading a right to clean water, what specifically the proponent of the measure is talking about.
Does the rest of the amendment tell them that?
It does not. So the only thing that voters were provided with, and this matters, is the summary is, shall the charter of the city of Titusville be amended to recognize a right to clean water and prohibit actions which interfere with this right? That's it. That's all they got. So you have 75 words as a proponent of a measure to explain what it is that your proposed amendment does. This didn't do it. Now, it didn't tell people something that wasn't true. It just didn't tell people anything. You could take that language, and we did in our briefs, and add language to it. Say safe schools, say clean streets, say good government. You could add those words to this charter amendment, and it likewise wouldn't mean anything because you're not telling people what it is that you're doing. Here, clean water doesn't mean clean drinking water, but plainly a voter could think that based on this language. And so where we'd like to go is talk first about preemption, because Florida law specifically, section 403.4129A, preempts local laws, including charter amendments, that recognize or grant any legal rights to a body of water. This, number one, does that. It grants legal rights to a body of water. You can sue in the name of the water.
Assuming you're correct, why doesn't the severability provision correct that? I say we just strike that portion. Doesn't the rest of the provision still would still be valid?
The problem is the rest of the provision, right? So if it just was that, if it just granted rights to water and then did something else, and obviously you have to assume that voters were told what it is that was going to be done because they were not here. But in theory you could, but not with this language because of the fact that once you start taking out the rights that this right to clean water grants, you are left with a shell that's empty that doesn't have anything.
Well, it seems to me that the part that you were alleging is expressly preempted would be the right to sue in the name of the water.
That's correct.
But my understanding is the ballot initiative also allows for people to sue to enforce their own rights to have clean water. Would that still stand if you preempted the first part?
It would not, and here's why. Because the state statute goes on. The statute provides that you can't grant any legal rights to a body of water or grant any specific rights to a person relating to the natural environment not otherwise authorized in general law, specifically granted in the state constitution. So if you can't show that the right exists in general law or otherwise is codified in the state constitution, the legislature has preempted granting any rights that don't otherwise exist. And that is exactly what this does. And we, in our brief, go through and show how this provides a prohibition on the government or a corporate entity engaging in any alleged, proposed, or continuing activity which violates the right to clean water. So that's one. That's something that doesn't otherwise exist in law, but now would exist once this charter amendment is enacted. You have standing. You wouldn't have standing otherwise to enforce. The state would, the EP would, but a person wouldn't. A resident of Titusville under the charter amendment now has standing. That's a right that plainly goes against the plain language of the statute. You also have the ability to recover monetary damages.
Well, you'd have standing, you just have to be able to show a discrete harm, correct? In other words, what this is doing is creating per se harm because your rights have been violated rather than I was harmed by the pollution that exists.
That is correct.
Okay.
And that's something that doesn't otherwise exist because it's per se, which you don't have. So it's something more. In addition, you have the ability to recover monetary damages to restore the water to this pollution-free state.
Again, why can't that be stricken and the amendment still be valid?
At that point, you have nothing left.
There's injunctive relief in the amendment, correct?
There is injunctive relief, but that is injunctive relief that otherwise wouldn't exist under Florida law. So the ability to obtain the injunction, you would not be able to obtain an injunction because you wouldn't have standing to obtain an injunction. So the injunctive relief wouldn't otherwise be available under Florida law.
Is this the same language in this amendment that also came out of the 6 DCA case? Is the language exactly the same, or is there some differences?
There are some differences, but they are slight. And so my understanding is that the main difference is the right to the water bringing suit in the Cypress
Wild Cypress
Branch case. That the water itself could bring suit, where here it's a little bit more vague in terms of who brings suit. But otherwise...
So Speak Up Titusville makes an argument that they can provide this amendment with stricter language than is provided in the statutes. I believe they reference Florida Statute 403.182 dealing with local pollution control programs. I mean, you would agree the language in there states that you can provide by ordinance, regulation, or local law requirements compatible or stricter or more extensive than those imposed by this act. So why does that not cut against your argument?
It doesn't, because if you would read that line again, what you would see is that charter amendment is one of the enumerated measures that a local government can enact. And so you can enact an ordinance, you can enact a local law, but you can't enact a charter amendment. That's not an accident. And so the legislature, when they wrote that statute, they understood that outside groups would perhaps want a charter amendment in order to establish a local pollution control program.
So if that language said charter amendment, then you would agree with their argument in regards to this?
If that language said charter amendment, they would have a stronger argument. I don't know that I would agree with it, but I think that the fact that it doesn't say charter amendment tells us that the legislature was specifically carving out charter amendments so that
Is a charter amendment akin to a local law?
it is not. And there are a number of other statutes that include the word charter amendment in terms of what a local government can do. It is excluded here. That's not an accident. And so the language itself, in terms of enacting a local pollution control program, it's important to note that first, this isn't that. This doesn't have the language that a local pollution control program would need in order to be enacted. That's number one. Number two, the language within the charter amendment never says that it's a local pollution control program. And it doesn't attempt to comport with a local pollution control program in terms of it doesn't submit anything to DEP, it doesn't seek approvals, it doesn't provide any type of metrics that fall within the rules that DEP enforces in terms of how you determine the amount of pollution, that the pollution standards. And so here you have a standard that is basically everything. If there's pollution, you trigger this amendment.
Well, it's a reasonable standard, so you'd be shifting the policy making from whatever administrative or executive body does it to the courts.
Absolutely. You're taking away the administrative, which has been preempted, but what they are attempting to do is to say judges are going to determine what is or is not pollution under this kind of vague standard.
Is that the city's, what is the city's concern here?
That is absolutely, that you don't know what is or is not in conformity with this charter amendment. That you don't know what is potentially harmful to humans or animals that somehow is not already covered under DEP guidelines or EPA guidelines. And businesses also are going to be subject to lawsuits where they don't know what the standards are. Currently, there's a statewide standard that applies, and even in localities where there are local community control programs, people understand what it is that they need to do to be in conformity with the law. Not here. Here you have a standard that is a sliding standard that some judge is going to write, but it's not the administrative standard that currently exists, and that's going to drive away business. It's going to undermine government. I mean, and the legislature specifically decided that this is something that they wanted to preempt and to stop and to say that if something like this is going to happen, it's going to happen on a statewide basis. That if you want to enact this standard, you need to enact a constitutional amendment statewide because it's still there. There's an avenue for speak up. If they wanted to enact or attempt to enact a constitutional amendment statewide, they would be able to supersede the legislative action in terms of adopting the statute. But when the legislature adopted a statute that specifically excluded this type of regulatory exercise on behalf of a local government, at that point you're preempted, and at that point under the case law, it's a closed matter. What this isn't, though, is it is not a local pollution control program under no circumstances. A local pollution control program has to be approved by DEP in advance. This certainly wasn't. It has to have a proposal in terms of what it is that it's going to do. This is a square peg in a round hole. Those two things they don't fit.
Does Florida Rock say differently, that DEP has to approve that up front?
And the Florida Rock case is interesting in that it precedes the legislative enactment of the statute in, I believe, 2020. So when 403.4129C is enacted, that is before. That is after Florida Rock, and so the argument in Florida Rock, they're different, and they're different on a number of levels. let's see. So in terms of, I do want to talk to the specific rights in terms of monetary damages. I don't know how one would restore water to its pre-pollution state. I mean, that is in and of itself a sort of a vague pronouncement that will inevitably lead to litigation, inevitably. And it will be litigation that will ensnare businesses and others in terms of its reach and scope. The Wild Cypress case also goes through, and these two cases, they are very similar. And the result in these cases, they're widely different. I also would point you to the orders on summary judgment in terms of their differences, and how the order here really just says that there's no preemption. The order also here goes through and with regard to the election matter, really doesn't provide any basis for its findings. So, in terms of the ballot summary, the ballot language, it is important to note that the language doesn't talk to the ramifications of the amendment at all. It doesn't talk about the main legal effect of the amendment at all. It literally just has a catchphrase. With that, I think my time is up. And so I will pass to the appellee unless the court has any other questions.
Nope. All right, thank you, sir.
Good morning, Your Honors. Richard Grosso on behalf of Speak Up Titusville. We would ask the court to affirm in both respects, title and summary, and the state law does not preempt. I think a lot of what you've heard this afternoon, this evening, this morning is questioning the wisdom or the policy decision, and that's clearly not an argument that can reasonably be made. That's not within the scope of review here. The title and summary, and I can't emphasize enough how many times the courts have told us that it has to be very clearly, conclusively, the title and summary invalid, that the court should exercise great caution in overturning the will of the people through the
Specifically, you're not allowed to hide the
process.
ball.
I'm sorry?
Specifically, you're not allowed to hide the ball is the term that frequently gets used. Tell us, so my earlier question about shifting the policy making from legislative, administrative, and executive functions into the courts, is that the core purpose of the initiative? And if it is, how is the summary not hiding the ball?
Okay. The core purpose of the initiative is very simple, to establish a local right to clean water. That's what the title is. That's what the summary says. If you vote yes, you will be enacting into our charter a right to clean water, and the text clearly does that. The very clear line of cases that have overturned titles and summary, there was always this misleading.
Currently, the ability to define what is and what is not clean water is a city legislative function. You can go to your legislative representatives and you can ask them to pass ordinances that say, you're not allowed to do this. What this does instead is give you the right to draw that decision into the courts and say, this is not a reasonable amount of whatever is in the water, and we want you, Judge, to determine that. My question is that a core function of your initiative?
Giving someone the opportunity to go to court and enforce the right is clearly one of the core functions.
Not just enforce the right, but define the right.
Yes, sir. But that's not unlike what current law is now. I mean, current law now, and by the way, the definition of pollution in our initiative is almost verbatim to the definition of pollution in state law, where the city has challenged it. It's unclear, it's ambiguous. they're challenging essentially the same definition of pollution in state law. But even when someone goes to court or an administrative hearing to try to enforce current state law and its definition of pollution, that in turn involves some trial court or an administrative hearing, if it's that kind of a case, where that judge or administrative law judge has to interpret and apply water quality standards, a definition of pollution, which are not always numerically objective things. There's subjective, narratively defined water quality standards. So it's not a different animal categorically from that. And on the question of preemption in terms of state law, I mean, it's just...
Let me ask you, we have I think we have very extensive laws in regard to water quality and pollution in Florida. What distinguishes this amendment from what's already in place?
What the distinction is now is that someone has a right under local law, not limited just to state law, to enforce a locally designated. It's as if the city itself wrote ordinances establishing a right to clean water. Obviously, the electorate has the ability to do that job for the elected officials. That's the difference. The body of state law is pretty broad on water quality, and it's not possible, I don't think, to read the entire body of Chapter 403 and Chapter 376 that the legislature exclusively granted to the Department of Environmental Protection authority over water quality protection. That can't be a reasonable argument. We've cited way too many statutes where it makes clear that local laws are to supplement the state's law. DEP has supervisory and guidance authority over water quality.
So going back to the local pollution boards, you weren't postulating that statute as the grounds by which this wasn't preempted, but as an example of the type of laws that exist to say that this is not, for lack of a better term, field preemption.
I think the answer is yes, but let me be clear. There is no implied preemption because the statutes in several different sections specifically contemplate that local governments would have the authority to supplement state water quality laws with their own. That's the argument here. That's why this is not clearly preempted.
What about the appellant's argument about express preemption, about the things that your ballot initiative does being expressly preempted by those provisions that say you can't grant a right that is not provided by general law?
And what we're saying is that there is no express preemption. You can't read that body of law that explicitly contemplates local regulation of water quality, which is what this is, and say that there's express preemption. That leaves you with an argument of implied preemption, but it's the same answer. First of all, they're both clearly disfavored. The courts have said it has to be very clear that the legislature meant to either expressly or impliedly preempt local regulation and in order to uphold home rule. And I don't think a reasonable argument can be made at all, given the number of explicit references to local regulations that are encouraged, and the Department of Environmental Protection is encouraged to work with local governments also in that respect. So, you know, that's a problem for the city.
Could you address the appellant's argument, though, that DEP is tasked, let's say, for example, in wetlands, in establishing water quality criteria? So they have tables, water quality criteria. How do you respond to that it seems you may be giving more rights as far as clean water than what DEP is setting down, what DEP is setting out?
Well, the first thing I would say to that, the first part of that response is that the statute explicitly allows for more stringent local regulations if a local government chooses to do that. That's the first part of that answer. I think the second part of the answer is that the definition of pollution and so the statute does not preempt, prohibit, preclude for a local government to say we want stricter, stronger water quality protections. It's not preempted. It's specifically authorized. I think that's really the bottom line answer to that. The one thing that is clearly preempted by the statute is the giving a right to a non-natural person, a water body, an environmental feature. That's clearly preempted but we don't do that. The reference in our amendment is nominal. A person must be the plaintiff. That person.
Maybe I didn't ask the question correctly.
Oh, I'm sorry.
Or maybe it was unclear. The charter amendment says clean water is waters that are free from pollution. I think what their argument was that DEP allows certain amounts of pollution to be in the water. And now you have a charter amendment that conflicts with that. And so that was the question I would like you to address.
Yes, Your Honor, and I'm sorry if I didn't quite get that at the
I may
beginning.
not have said it correctly to you.
The definition of pollution is that the introduction of pollutants that are potentially harmful or injurious or which unreasonably interfere meaningfully with recreation and other uses. It's the same definition. It's not a different definition. It's the same one. The city speculates that this might be interpreted, applied, enforced in a way that would require cleaner water than is required by the state. Number one, that's speculation. Number two, that's not prohibited. That's the key point in our arguments to you, is even though the state does have its definition of pollution, the state specifically allows local governments to have stricter pollution standards if they so choose. The electorate obviously here has so chosen to do that. And so the argument that people weren't told that this could allow standards that are stricter than federal or state law, that's not clear that it does necessarily, but also the cases that address that.
Not just stricter, but this could, in theory, cut the other way as well. Going towards the city's argument that the ballot language was not effective, or the summary was not effective, let's just, for hypothetical sake, say the entire judiciary is infested with a bunch of corporatists who don't care about water quality. You've put forth an amendment that tells people they have a right to something, that something is clean water, which is undefined, and in the charter amendment, it's defined as what's reasonable. If you have an entire judiciary who finds the reasonable standard to be way up here, you've essentially given the people no right at all, in conflict with what your ballot summary said.
I don't know, Your Honor, that that's categorically different.
I mean, it's a big hypothetical. I concede that.
But my direct answer is I don't know that that's categorically different than any law I've ever stood in front of an appellate court and challenged or defended before. Every law that's on the books, a state law, local law, whatever, ultimately comes down to a trial judge and then an appellate panel saying that's what it means. That's categorically how the system works. I don't see that that is viewed as something that invalidates the title of the summary. I don't see that that's anything that helps the city achieve its burden of showing clear preemption. We're all at the mercy, if you will, of how good lawyers are at explaining to judges what things mean and how they apply, and that's the end of the line on any case. I don't know that I can respond any better than that, but categorically that's not different than any ordinance that a local government adopts where no one's even challenged its validity. It's part of what we do in our business, I think.
It's not a difference in scope, or it's not a difference in kind, but it may be a difference in scope. Yes, any ordinance is going to have some wiggle room and some play, and that's going to come before the courts to be sure, but where the standard is just your right is whatever is determined to be reasonable, that's a pretty, would you concede that's a lot broader of a standard when you're telling someone that they have a right to something?
Again, if that's an infirmity of this language, then it's an infirmity of existing state law definition of pollution. I mean, as someone who's done environmental and land use law in the state for 30 years, our statutes are full of terms that require some application, some interpretation when applied to any particular set of facts. Laws are written that way in this area in this field of law because Everything's site-specific. Every water body has its own characteristics. Every piece of earth, every jurisdiction has unique features. And so when the legislature writes laws, when local governments write ordinances, they tend to not be, because you just can't, I can't write a law that says on this water body, this is exactly what happens, on that piece of land, that's exactly what happens. You make policy decisions that are reasonable, and then you let them, as many of the cases we've cited have said, some of those details are just simply going to have to be worked out during the application and potential litigation of these amendments.
What happens to legislative policy in the wake of this charter amendment? So, for instance, City of Titusville passes an ordinance that says you're not allowed to have more than so much green dye in the water. Does that have its own independent standing at that point, or under this, when you sue, does that just become a piece of evidence that goes before the judge? That this is what the legislative policy determination of the amount should be, but because it's a reasonable standard, judge, that's only evidence.
I think that if a cause of action is brought under this language, it is enforcing this language in local circuit court. I think that what the state law says or does not say on that probably does not enter into the picture. That's not the law that's being enforced. To the extent that there's similarities, like in the definitions of pollution and that sort of thing, I would think that agency interpretations or judicial interpretations of the same language under state law is probably going to be, at a minimum, persuasive authority, I would say.
Well, I mean, just to make my question, I guess, a little more direct, if the people of the city of Titusville went to their city council, their legislative body, and said, we want an ordinance that says this is the allowable level of, I'm using green dye because I'm not super familiar with different pollutants, but I've at least seen St. Patrick's Day parades. That said, they go and they say, this is the policy decision that we're making through our legislative representative. So we want this to be the allowable level. But then another citizen, perhaps not in the majority of that position, then sues under this provision and says, no, I have a right to clean water. And that allowable level that the majority of folks voted upon, that's only evidence of what's reasonable and what's not reasonable. And here are all my arguments why it's not reasonable. Do I have a correct analysis on how this would play out?
I think that's probably not far off at all. Yes, it's ultimately, there's going to have to be technical, scientific evidence as to why a certain level of pollution does or does not trigger the standard. But again, I think that that's inherent to the area of environmental law and pollution law, just characteristically. I hope I answered the question, Your Honor.
You do, but this leads me back to my very original question. Is supplanting the majority will of the people expressed through their legislative body and creating a counter-majoritarian right that overrides that a core function of this charter amendment? And if so, was that actually appropriately conveyed to the people?
How I would articulate that is that the chief purpose was to add a supplemental additional right. It doesn't negate anyone's ability to enforce existing state law. And that's the answer. And that clearly was articulated. It was clearly expressed in the title and the summary, and it's exactly what the text did. But again, that devolves back to the ultimate question of, does Florida water quality law preempt versus allow local governments to have their own stricter water quality standards? And the answer is yes. And clearly the appellants here, the city, have not met the burden of showing that that has clearly been preempted. Now, they've come and they've argued it's a bad idea. It might have some of the complications, Your Honor, that you've talked about. That goes to the question of the wisdom. Was it a good idea for us to have our own standard that then might give rise to people having to defend it or be challenged under it? That's a choice that the voters get to make, and they made that. And the city's disagreement with the wisdom of having done that obviously can't be entertained at this level, at the appellate level, because of separation of powers. And courts, we've cited at least 3 cases where courts have said, you know, the details, what's the equivalent of marriage, what's fair market value. I'm forgetting the other case that we've cited, but the courts have said that that's a level of detail that has to be left to implementation, potentially litigation.
So if I'm hearing you correctly, then this right that you're discussing, the right to clean water, is not specifically authorized in general law or by the Constitution. Is that what I'm hearing you say?
Oh,
This
no,
is
I think
an
it is.
additional right?
I think it is, because Florida law does
Where in
allow.
the general law is that right provided?
Your Honor, we've cited a number of statutes. 403-021, subsection 4, local water pollution control programs are to be supported as essential instruments of a coordinated statewide program of water pollution prevention. 403-088-4B, the section shall not be construed to exempt any permittee from pollution control requirements of
That's
any
fine.
local.
I thought you had told Judge McIver that this was in addition to what was provided by general law or not granted in the state constitution. So that's fine.
I'm sorry. What I thought I said, what I meant and hoped to say was that this legal requirement of a local clean water would be an additional requirement that anyone would have to comply with in addition to state law. I hope I didn't mislead with my answer on that, Your Honor. And if I can remember where I was. Okay, so the courts have said very clearly, the bottom line is people, and we've got the Durst case and others that have said clean water is clean water. People understand that. They're not misled. There wasn't anything about our title or our summary that suggested, oh, we're giving you a right to clean water, but then the text is, no, we're really not. And the courts have overturned summaries and titles where the text used different terminology, different phrases than was in the title and the summary, where the title and summary didn't tell you. They said, oh, this is going to prohibit casinos. This will limit casinos. Didn't tell you they're already prohibited. It's things where you're hiding the ball. We're not telling you that, like the term, the lobbying case. This is a limit on lobbying. Well, there's already was a limit on lobbying, and what the amendment actually did was allowed you to go lobby your agency without a 2-year waiting period. It's things like that where the court said you would have voted
Wrap it
differently.
up, sir. You're over your time. If you could just wrap it up.
Where the court sort of said you would have voted differently had you been told that. There's no basis at all to conclude that had there been anything different in the title and summary, voters who wanted a local clean water right would have voted for a local clean water right. And we thank you for the opportunity to explain this, and I'm happy to answer any other questions if the court has any, but I appreciate your time very much. Thank you.
Thank you, counsel. All right, just under 5 minutes, sir.
Thank you, Your Honor. There is no right to clean water as defined by the Charter Amendment in general law in Florida. The Charter Amendment's definition of what clean water is and any law on the books conflict. There is no such thing. And as much as counsel says, well, there are local pollution control programs, and so there's the ability under certain circumstances for additional regulations to be in place, I would point out that under section 403-182(1), section A, that any local pollution control program must first be approved by the department as adequate to meet the requirements of the act. So that's not there. What they're talking about is conceptual, in that you could have some regulations that are approved by DEP that exceed the standards that generally apply in the state. And while that's true, that does not mean that you have the right to create your own standard without DEP, which is what they are attempting to do. I understand the notion of saying, well, we have this on our books, but it's really not effective, which is, I think, what they're trying to say, which is, okay, allow our charter to have this language, but it can't really go into effect without DEP authorization, without other approvals somewhere else. Well, there's no standard in this language. There's nothing in this language that would allow DEP to do anything with it. And so there's nothing here that would allow a local pollution control program to be enacted. That's not what they were doing. And that's not what this charter amendment does. We believe that the plain language of the statute, that when the legislature enacted 403.412(9)(a), that they knew what they were doing, that language was there for a reason and purpose. That's an environmental statute. They understood that some measure like this could come down the pike. And that is plainly what this language is attempting to prevent.
Did they understand that a measure like this could come down the pike, or wasn't that passed in response to a measure like this that had come down the pike?
My understanding is it was passed in response to a measure like this that had come down the pike. And the distinction between this and what was enacted in Orange County is exceedingly minor. And no one can establish or explain what is different in terms of what it is that we're doing, because the definition of what pollution is under their language in the charter it encompasses nearly everything.
And you don't have a lot of time, but can you address your opposing counsel's argument? I mean, how is that different than any number of the laws? Okay, springing to mind immediately, think of other counter-majoritarian rights. Your right to be free from unreasonable searches and seizures. Pretty broad. And then that gets defined by the courts. How would this be different than something like that?
The difference is that you don't have an overarching statute that cuts off your ability to be so broad. And so if this were a constitutional amendment, okay, you can make that argument.
Well, it's the local government version of a constitutional amendment, right?
But it's preempted by state law. And the state law preemption, the contact between state law saying you can't do this unless it's already in general law, inhibits their ability to do something like this. That their problem is that general law doesn't exist that specifically provides the definition that their charter amendment provides. That doesn't exist. And they're attempting to shoehorn by saying, well, there are certain measures where DEP has approved, and there are other instances where there are other more broad regulations. But those regulations are approved in advance by DEP. That didn't happen here. So this cannot go into effect without DEP approving. But that's not included in the charter amendment language. People here were told they're going to have a right. They're not going to have a right without DEP doing something about it. And they weren't told about that either. They were given effectively a false bill of goods. They were told that they were going to get something, and in fact, they can't possibly get it because state law cuts them off. So unless there are other questions, I know I'm out of time. We would ask the court to overturn the summary judgment order entered by the lower court to issue an order striking the charter amendment and then referring it back to the circuit court for further action. Thank you very much.
All right, thank you, counsel. Well argued, well briefed case on both sides. We will take the matter under advisement. This time we'll stand in recess.
All rise.